And this is a case between Dolby as the claimant and Roku as the defendant that was decided here before the Unified Patent Code, the Munich local division of the Unified Patent Code. In this case, we had a not an interim license application before a foreign court as the subject matter of the proceedings, but it was an anti-suit injunction, respectively an anti-enforcement injunction that was brought or potentially raised before the US court. That was the point of dispute between the parties. Maybe just very briefly, what is an anti-suit injunction or an anti-enforcement injunction? These are basically rulings from a court which shall prevent a party from either starting or continuing proceedings regarding patents, infringement of patents in another jurisdiction, or this is the anti-suit injunction, but and the anti-enforcement injunction are orders that prevent a party from enforcing an injunction or enforcing a judgment that has been obtained in another jurisdiction until the court that has granted the anti-enforcement injunction has decided the case. So this again was here the topic: anti-suit injunction, anti-enforcement injunctions that could potentially be granted in the US, and what remedies could be granted by the UPC to prevent that from happening. Here we had Dolby in May 2024 filing the infringement lawsuit before the UPC. And at the end of 2024, Roku also filed a lawsuit in the US. What is interesting about this lawsuit is that the so-called prayer for relief included also a motion for an anti-suit injunction and an anti-enforcement injunction. What is interesting to note here is that, according at least to the analysis of the UPC, these motions that have been included in the prayer for relief were not, let's say, active automatically, in the sense that they needed an additional application by Roku in order for the court to be able to address them and to decide about them. But so they were included in the prayers for relief, but there was an additional application needed for the court to actually decide these motions for an anti-suit injunction and an anti-enforcement injunction. As a reaction to that, Dolby went to the UPC and asked for an anti-suit injunction and an anti-enforcement injunction. So this would be then interim injunctions that should prevent, in simple terms, Roku from obtaining an anti-suit injunction or an anti-enforcement injunction in the US. This happened on the 23rd of January 2024. So this is when Dolby filed this motion before the UPC. On the 27th of January, so 4 days later, Roku declared via an email that it will refrain from the anti-suit injunction and the anti-enforcement injunction in the US. 1 day later, after this email, the UPC granted an anti-suit injunction and an anti-enforcement injunction, and this was granted again ex parte, meaning that Roku had not been involved by the UPC in the decision. But at that point, this anti-suit injunction was there. The UPC had made this order, had granted this interim injunction. Then this injunction was served to Roku in the US on the 4th of March 2025, and the day after, Roku decided to amend the prayers for relief in the US proceedings, and at least in the view of the UPC here, that meant that these motions for an anti-suit injunction and an anti-enforcement injunction were no longer applicable. So it basically were removed from the proceedings. Apart from that, on the 31st of March, and then 3 days later, on the 2nd of April, Roku also made a cease and desist declaration with a penalty clause regarding this, the anti-suit injunction and the anti-enforcement injunction. Maybe here as background information, what is this cease and desist declaration with a penalty clause? This is something that is used as a tool in Europe and also in Germany, particularly, in case that you have this type of interim proceedings, because by this cease and desist declaration, what the declarant, in our case Roku here, does is basically to declare or to undertake not to do what it should have not do what the other party requires, and it also commits, if it nevertheless does what it has promised not to do, to pay a penalty. So this is what was the case here. Roku made this cease and desist declaration. There were two versions. The second one was, at least according to the court here, more or less accepted by Dolby. So that meant that these proceedings that were pending before the UPC, which were directed to measures against the anti-suit injunction and the anti-enforcement injunction, had no longer any importance because now the things had been settled. Now Roku had undertaken not to do that, not to go forward with these applications in the US, and in the meantime it had also amended its prayers for relief. Now the question that remained was, who is going to now take the cost for the proceedings before the UPC concerning this anti-suit injunction? And this is what the court did with this order that we're looking at today. It ordered Roku to pay the cost for the interim and the anti-suit injunction proceeding. And we're going to see what was the reason for that. Now, as I said already, what the court first established here is the fate of these proceedings. And again, as I mentioned already, it accepted that that Dolby's motion for an anti-suit injunction and an anti-enforcement injunction has been settled on the merit, because there is no threat for infringement anymore, since we have this cease and desist declaration. And since these declarations have been made, also Dolby has not a claim anymore for asking Roku to cease and desist from proceeding with these motions in the US proceedings. So the case was settled. That was clear here, and this was not also very much disputed by the party. What was disputed was who needs to take up the cost. And here there is one provision which is relevant for this question, and it's Article 69 of the UPC agreement. I'm just adding that here in the slide so that you can see what this article is about. But maybe to sum it up, there is the principle that the party that loses the proceedings, here in this provision, it is named the unsuccessful party, needs to pay for the reasonable and proportionate legal costs of the other party, of the successful party. So this is the principle, that the party that loses the proceedings needs to pay for reasonable and proportionate legal costs. There are exceptions from this principle. For example, if equity requires otherwise, there can be apportionment of the costs, but there must be reasons for that. And we're going to see in a moment, the court also looked at that here in the present case, whether there are exceptions from this principle that apply in the present case. Now, we've said the principle is the party that wins needs to pay nothing, and the party that loses needs to pay the cost. What happens if there is a party that succeeds only in part? Then, in this case, or in exceptional circumstances, there is an apportionment. So both parties need to pay part of the costs or bear its own cost. This is also a possibility. Again, we're talking about reasonable and proportionate legal costs in this case. So this is the scenario where you have a party only winning in part. What happens, however, when we have costs that are unreasonable or unnecessary costs? There you have another exception, that if there are unnecessary costs being incurred in the proceedings, then the party that has caused this cost needs to cover that as well. So here, just for you to get an impression, what is the legal standard behind that and how the legal costs of the proceedings are being handled in UPC proceedings. And now let's take a look at how the court applied this in a specific case here. So, of course, the first question was to determine who is the successful and who is the unsuccessful party. And in the eyes of the UPC, the unsuccessful party in the present case was Roku. Generally, the court said if you have situations where the defendant undertakes to meet the claimant's request, then as a rule, it is the unsuccessful party. So if you have situations like here where Roku made the cease and desist declaration that corresponds to Dolby's claims, then it should be, as a rule, the rule would be that it is the unsuccessful party. Here, particularly, the court said whether it was the initial declaration, cease and desist declaration, or the amended declaration was not made no difference here, especially since the second one was definitely sufficient. But here, the fact that Roku had basically made this declaration that meets all the requests of Dolby, if we want to put it in simple terms, then it was, in the eyes of the court, clear that Roku was the unsuccessful party. Then, what the court pointed out here as well, interestingly, is that in this case, when you have this type of undertakings, to burden the party that is unsuccessful with the cost does not require the court to examine whether the claims to which this undertaking corresponds were admissible and well-founded in the proceedings. So in other words, if undertaking is this declaration, it is not important anymore whether the actual claims would have been successful in the proceedings. This is interesting because if we look at the decision further, the court actually made this analysis here. So it made, to a certain extent, an analysis of whether the request, the motion of Dolby for an anti-suit injunction or an anti-enforcement injunction would have been successful here. And the conclusion was that Dolby's motion was not evidently inadmissible or unfounded. So the court made here a bit of an assessment of this claim and basically an assessment of whether an interim injunction would have been granted if Roku had not made this cease and desist declaration. So it looked again to these two elements we have discussed before that are relevant. If there is a claim, a right that needs to be protected, here in the eyes of the court, clearly the property rights of Dolby are arising from the patents, and the issue of urgency. And in the eyes of the court, there was urgency here because the prayers for relief in the US trial established this risk of first infringement. So you could very fastly move to this in the US proceedings and have then the US court granting an anti-suit injunction or an anti-enforcement injunction. So the requirements were met. The risk was there, and property rights of Dolby should have been protected in Germany. Now, the fact that the anti-suit proceedings in the US would have required a separate motion to be kicked off, basically, so that the court actually decides on this case, was not seen as relevant for the court. Especially, it was not seen as a factor that could diminish the risk of first infringement. So having said that, the court then examined whether this risk of first infringement had been removed before the decision was granted, and it found that it had not. Particularly this declaration that I mentioned before of Roku in an email that it would not move forward with the anti-suit injunction in the US proceeding was not found to be sufficient because it did not clearly indicate that Roku would waive these claims. And apart from that, even if you would assume that it was the case, it was very unclear whether this declaration had a legal binding effect or not. And the court was not sure that Roku would be prevented from further pursuing an anti-suit injunction in the US based on this email. So it left the fundamental question open whether just an informal declaration in an email would be sufficient or you would need a formal, let's say, cease and desist undertaking. because it found that this declaration in terms of content was so uncertain or unclear that it would not suffice to remove the risk of first infringement. When did this happen? The court said this happened only when Roku had amended the prayers for relief on the 5th of March in the US proceedings. Because then, in the eyes of the court, with this amendment, the risk that you would have a first infringement of the property rights of Dolby was fully removed. After that point, there was no risk anymore that you would be hit with an anti-suit injunction or an anti-enforcement injunction from the US. However, this amendment was done after the UPC had granted the anti-suit injunction, the anti-enforcement injunction. So in this sense, it was not so much relevant for whether the claims, at least at that point initially, had value or had been admissible or founded. Having said that, there was some discussion also whether there were other factors that had removed the urgency for any interim measures in the UPC proceedings. There was some discussion again about how the anti-suit injunction proceedings in the US would work, and the fact that you would need a separate motion, so that you would need some time basically until you get a decision from the US court. You would have, even if you had this motion, Dolby would have gotten 14 days to respond. So it would not be granted automatically, basically, an anti-suit injunction in the US, or whether there had been, let's say, whether a prior notice had been required, etc. But the court did not see many merits in that. So it's basically the conclusion was that, as the case was here, there was justification for Dolby to move on with this motion for an anti-suit injunction and an anti-enforcement injunction before the UPC. So finally, I mentioned in the beginning, we have these exceptions where not the successful part, where the unsuccessful party shall bear the cost of the proceedings. And the court examined also a little bit here whether any of these exceptions would apply here. It did not see that equity considerations require Dolby to bear any costs for the proceedings. It said basically there is an exception possible if you have filed an action without any prior notice, and then the defendant, when he gets in the proceedings, directly makes a cease and desist undertaking at the start of the proceedings. So in this case, you might say that equity or other considerations in that direction would maybe justify an exception in, and splitting the cost, maybe, or even asking the patent owner, the claimant, to bear the cost. But this was not something that the court saw in the present proceedings. And what the court also did not see here is that the way Dolby acted and the cost that it created by initiating these proceedings for an anti-suit injunction or an anti-enforcement injunction, that these costs were unnecessary. So if you remember, we said that this is an exception as well. So the one that causes unnecessary cost needs to cover these costs. But here the court was not convinced that the cost that has incurred had been unnecessary. And basically, to examine that, it asked the question: how would you have seen the case from the perspective of Dolby at the moment that this motion was filed? And this court said, from an objective viewpoint, on the one hand, a party in Dolby's position could not assume that it would not need to take this measure before the UPC, because again, at that point in time, the prayers for relief in the US trial included motions for an anti-suit injunction and an anti-enforcement injunction. So this gave reason for Dolby to take countermeasures. And then there was a debate around the question of whether it was justified for Dolby to start, let's say, with the motion for an anti-suit injunction before the UPC without making a prior notice. And here the court said it was not actually needed. So generally, if you have situations where proceedings for an anti-suit injunction or an anti-enforcement injunction have been already launched abroad, then it is not required for the patent owner to make a prior notice before asking for countermeasures. Why? Because by launching these proceedings, the applicant, or in our case here, the implementer, willfully aims at limiting enforcement. So it's clear that this is the intention. So at the end of the day, making a notice before launching anti-suit injunction proceedings at the UPC wouldn't make any sense. And this is what the court believed, particularly for the present proceedings, because it said even if Dolby would have made a prior notice before asking the UPC to grant an anti-suit injunction, this would have been obsolete, since there was no prospect of success. Especially, you could not expect that if this out-of-court notice had been granted here or had been given to Roku, that it would have removed the claims from the US proceedings. Not only that, the court said that a prior notice would not only be obsolete, but also impractical in the present, because it could not be ruled out that if you would inform Roku that you are intending to take countermeasures before the UPC, this could eventually expedite the US proceedings and have the respective request filed pretty fast as a reaction to that announcement, more or less. So that also from a practical perspective, it wouldn't have made sense here for Dolby to make prior notice before it has filed the motion for an anti-suit injunction before the UPC. So this means, of course, that the costs that have incurred for this application, for these proceedings before the UPC, were not unnecessary, because basically they could have not been avoided even if a prior notice would have done before the proceedings were launched. So this is the decision here in a nutshell. Again, what is interesting here is, of course, all the considerations of the court regarding the cost issues, which are very detailed here. We have a very detailed analysis of all the many potential aspects that can play a role here. But apart from that, I think also the elements which the court has described as potential factors that speak in favor of granting this type of protective measures against motions for an anti-suit injunction or an anti-enforcement injunction coming from abroad also indicate to a certain extent the way the UPC thinks about this type of measures. Of course, we are going to see going forward whether this is mirrored also in more decisions, also actual decisions for an anti-suit injunction, an anti-suit injunction, or an anti-enforcement injunction by the UPC in the future.